Biden administration is outright defying a Supreme Court 6-3 decision that blocked his office from forgiving billions of dollars worth of student loans. The Biden administration has now circumvented that decision, which is going to have nationwide implications, and ultimately it reveals also what they're going to do in future agency cases like what's going on against the ATF in all of our 2A cases. So let's talk about what now has happened. Now, before we jump into the video, I want to thank one of the sponsors of the channel, which is 1st Phorm. A lot of you are aware that over the last year, I've kind of been on a fitness journey, and I'm still kind of on that journey trying to lose more weight and get healthier. Now, one of the companies I'm currently working with that I was using during the whole process is 1st Phorm. 1st Phorm has amazing supplements. I use their protein every single day. Now, one of the really cool things that they're offering to my viewers here, you guys, is that if you guys sign up using the link down below and you're signing up to 1st Phorm for the first time, you can get 30 days of a free trial of their new fitness application. This app has a lot of different components in it. It helps you track your macros. It helps you along kind of with your fitness journey. And then you also get a dedicated coach who can help you with whatever goals you have. So again, 1st Phorm is an amazing company. They believe in the Second Amendment. They appreciate firearms and what we're doing here on the channel. So if you guys are interested, check them out. And then again, don't forget you can get that 30-day free trial. As I mentioned in the intro, in this video, we're going to be talking about a major Supreme Court decision that is now being directly defied by the Biden administration. The case we're going to be breaking down is called Biden versus Nebraska. The case was decided 6-3 against President Biden and his administration's attempt to essentially interpret a federal law how they wanted to create a new law which would allow them to forgive billions of dollars worth of student loans. Now, although this case deals with non-2A issues, at its core, this case is still very important for the 2A cause. That's because this case is about what powers an executive agency has to go beyond the express text of a statute. And again, that's very relevant for what the ATF also does all the time. This case is about whether the Department of Education, at the behest of President Biden, could create a new program which would on its own forgive billions of dollars in student loans using the HEROES Act as a basis. The Supreme Court, in a 6-3 decision authored by Chief Justice Roberts, found that they could not do that type of thing. But one of the interesting things that has now developed and was kind of hitting the news cycle is the fact that the Biden administration has now decided to outright defy the Supreme Court's 6-3 decision in this student loan case. And they decided to engage in conduct that they can essentially unilaterally forgive billions of dollars in student loans despite what the Supreme Court said. Now, in reality, we know that they're not just forgiving all these student loans. Instead, they're going to put it on the taxpayers to have to fund this and pay for this. But right now, the Biden administration and Biden himself came out saying that despite what the Supreme Court said in that 6-3 decision, they are going to do what they want to do. They are not going to adhere to that decision. Now, for some context of what we're dealing with agency actions in the Supreme Court decisions that have now stacked up, we need to talk about a few cases, one of those being the West Virginia versus EPA case. In the West Virginia versus EPA case, the Supreme Court denied deferring to the EPA's interpretation of the Clean Air Act, and instead they looked at the major question doctrine. Under the major question doctrine, the Supreme Court declared that if an agency seeks to decide an issue of major national or economic significance, its action must be supported by clear statutory authorization. Therefore, in that case, the Supreme Court refused to defer to the EPA's interpretation and instead said that it was on Congress and it was Congress's job to make the law, not the EPA itself. Now, in another case, Sackett versus the EPA, the Supreme Court further refused to defer to the EPA's interpretation of what they believed were the waters of the United States. On review, the Supreme Court found that the statutory language did not include the property that was in question. They also found that even if the term was vague, the criminal implications that were included in their new rule would mean that the EPA would only then have the authority over things that Congress clearly included in that statute. Now, with both of these rulings, it showed that at least in the EPA context, the Supreme Court was going to be very aggressive in curtailing agency overreach. Then we got the Biden versus Nebraska decision that reined in another agency action, and this decision was also very significant and had some significant language, but again, it went directly against an agency's new interpretation, and that one specifically was about student loans. In this 6-3 decision, the Supreme Court outlined the timetable for what the agency did and the ultimate flip-flopping of interpretations that the agency also created. Justice Roberts stated in his opinion that during the first year of the emergency, the department's Office of General Counsel had issued a memorandum concluding that the Secretary does not have the statutory authority to provide blanket or mass cancellation, compromise, discharge, or forgiveness of student loan principal balances. However, after a change in presidential administrations and shortly before adoption of the challenge policy, the Office of General Counsel formally rescinded its earlier legal memorandum and issued a replacement interpretation, reaching the opposite conclusion. The new memorandum determined that the HEROES Act grants the Secretary authority that could be used to effectuate a program of targeted loan cancellation directed at addressing the financial harms of the emergency. So in this case, the agency in question had an original interpretation that found that they could not directly forgive student loans under the statutory language. Then suddenly, when the president changed, they changed their minds, rescinded the previous memorandum, and issued a new interpretation that, oh, by the way, now we say we can do this. If that flip-flopping of interpretation sounds very familiar and very relevant for the ATF context, that's because it is. This is the very thing that the Supreme Court found issue with this agency doing, and that's exactly what the ATF does all the time, what they did with bump stocks, what they did with pistol braces, what they did with unfinished frames and receivers, and a lot of these examples are now finding their way back up to Supreme Court. The Vanderstock case is going before the Supreme Court. We have the Cargill case that's going to have oral arguments taking place very soon in front of the Supreme Court, and it has to do with ATF interpretations, changing them, flip-flopping, and saying, oh, by the way, all of a sudden, this, forget what we said for prior years, 20 years, now this is our new interpretation, and this type of conduct is illegal. The Supreme Court in this Nebraska 6-3 decision is stating that this type of flip-flopping by an agency is not permitted. The statute in this case even permitted small modifications to the program, but what the agency did is create something completely new, which they themselves even admitted prior they could not do. Because of this, the Supreme Court then outright rejected the Biden administration's argument that all they did is simply modify the current approach. Then in this same opinion, Justice Roberts hits generally on agency overreach. He stated that the question here is not whether something should be done, it is who has the authority to do it. Our recent decision in West Virginia versus EPA involves similar concerns over the exercise of administrative powers. So too here, where the Secretary of Education claims the authority on his own to release 43 million borrowers from their obligations to repay $430 billion in student loans. The Secretary has never previously claimed powers of this magnitude under the HEROES Act. Under the government's reading of the HEROES Act, the Secretary would enjoy virtually unlimited powers to rewrite the Education Act. The dissent is correct that this case is about one branch of government arrogating to itself power belonging to another, but it is the executive seizing the power of the legislator. The Secretary's assertion of administrative authority has conveniently enabled him to enact a program that Congress has chosen not to enact itself. So what does this all mean? Well, in this decision, in a 6-3 decision, the Supreme Court stated that an agency cannot go beyond the authority that the statute expressly states. Shocker, right? Well, that's how our nation is supposed to work. That's how statutes are supposed to work. That's how interpretation is supposed to work. That's how the law is supposed to work. But we had to have the Supreme Court say and tell the Biden administration, no, you cannot just have your agency interpret a statute vaguely however you want, come up with a new rule, and then, oh, by the way, forgive billions of dollars worth of student loans. And again, it's not really forgiving it because it essentially just puts the money off of the student loans, off of the people who took the student loans, and puts it on the taxpayers. But now what we've seen develop just this week is despite that decision by the Supreme Court, suddenly the Biden administration came out and said that his administration and his office has in fact still engaged in trying to quote unquote forgive billions of dollars in student loans despite what the Supreme Court said. During a press conference, Biden stated expressly that the Supreme Court blocked it, but that didn't stop me. So they are still engaging in a new program where they're going to forgive a bunch of money, despite what the Supreme Court said in the Nebraska decision. What this clearly signals is that the left is not going to play by the rules. They, again, never want to play by the rules. And I suspect that that is also similar going to happen with other agency decisions that are currently pending in front of the Supreme Court. The Supreme Court is set to hear a bunch of ATF cases, the Cargill case, that bump stock case. The Biden administration, if they get a negative decision against them, I suspect that the agency is not going to just decide to, yes, we're going to adhere to that. We've seen in multiple contexts that they will not adhere to any Supreme Court decision, especially trying to curtail agency overreach. And I suspect even what would happen in Cargill is probably going to be similar to what now happened with the student loan case. Again, although this does not deal directly with a two-way issue, all of these things play off each other, especially in the agency context. A lot of these cases are cited to directly in cases against the ATF and those agency overreach. So it's going to be very interesting to see how this develops and how this plays out going forward. If you guys have any questions, go ahead and comment down below and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars and this nation will be maintained by armed scholars.